Bienenfeld Law with Saul Bienenfeld.
Tonight, I need to talk to you about something that sits right at the intersection of fear, law, and the human need to ask for help. It's a question I get constantly, sometimes whispered, sometimes typed into an anonymous forum, sometimes from someone who says, look, I have this friend, they're terrified to talk to a therapist because they don't want to be reported. So what I'm talking about tonight is mandatory reporting. What is it? Who does it apply to? And how does somebody get help without triggering an automatic call to the police or child services? So let's pull this apart carefully, because the truth is, navigating this line can mean the difference between treatment and a life-altering criminal investigation. So let's examine who is a mandated reporter. Mandatory reporting varies from state to state, but the main categories almost never change. Teachers, social workers, psychologists, therapists, medical professionals like nurses and doctors, some clergy in certain jurisdictions, and sometimes it could be an attorney, but usually it's not an attorney. It depends on a lot of different factors. Now, these people the law designate as the early warning system for abuse, neglect, or imminent danger. They don't get to choose. They don't get to weigh it morally. If they see certain things or hear certain things, the law says you must report. And the penalties for not reporting can be severe. It could be civil liability, criminal charges, professional discipline. So most professionals understandably err on the side of caution. Now, what exactly must be reported? Mandatory reporting is not a free-for-all. A listener's friend telling a therapist, I stole something once, or I cheated on my taxes, or I'm struggling with inappropriate urges, does not automatically trigger a report. The law requires reports when a professional has reasonable suspicion of child abuse or neglect. That includes physical abuse, sexual abuse, exploitation, severe neglect, or exposure to dangerous environments. Also, reasonable suspicion of abuse of vulnerable adults, so the elderly, the disabled, or otherwise dependent adults, and threats of imminent harm. All right, so those are the three categories. Reasonable suspicion of child abuse or neglect. Number two, reasonable suspicion of abuse of vulnerable adults, and threats of imminent harm. And so that could be a serious plan to harm oneself, a serious plan to harm somebody else, and in some states, a credible threat toward an identifiable victim. That's what it's called, a credible threat to an identifiable victim. So I plan on killing the president of a certain corporation. So that's a credible threat of an identifiable victim. Now, here's what's important. Past acts that don't involve a currently endangered child usually do not create a reporting duty. So if someone says, my friend did something 10 years ago, or my friend has thoughts but no victims, no access, no plan, most therapists, unless they hear evidence of current danger to a child or a vulnerable person, don't report. And if a person says to a therapist, 10 years ago I did something, or 10 years ago I caused pain to somebody who was a child, it should not be reported because it happened in the past and there's no current danger to a child. Who gets the report? That's a good question. Who gets the report? So when a report is triggered, it typically goes to Child Protective Services, Adult Protective Services, local law enforcement, or the state abuse hotline. The mandated reporter does not get to play investigator. They don't get to determine guilt. They don't conduct interviews. They don't track down evidence. Their job is simply to say, I'm concerned, please look into it, and that's it. So, unfortunately, people are afraid to seek help because of this. And this is part that nobody talks about. A lot of people, your friend, your coworker, someone listening right now avoids therapy because they're terrified that even admitting thoughts could ruin their lives. And the tragedy is that so many people who most need mental health support stay silent out of fear, shame, ignorance of what the law actually requires. But here's the truth. The law distinguishes between thoughts, urges, and imminent risk. A therapist is not required to report because someone struggles. They report if someone is about to cause harm or a child is currently in danger. That distinction matters. How someone can seek help without triggering a report is a very important topic we should be discussing. So let's talk strategy, hypothetically, of course, because we want people to get help safely and legally. So one option is to use hypotheticals. A person might say, I have a friend who's struggling with X, or I want to understand the law so I can better support someone else. Therapists can still guide, advise, and help the process without a report if you're talking about somebody else. But number two, you could focus on thoughts, not actions. A mandatory reporting usually focuses on conduct of imminent plans, not on internal states. So talking about urges or fears or compulsions or guilt without identifying a current child in danger does not typically meet the reporting threshold. And do not name identifiable minors or victims unless you intend to trigger a report. There's a difference between I sometimes get intrusive thoughts and I'm currently alone with a specific child, and that distinction is life-altering legally. So be careful what you do say. And you have to understand what imminent means. I feel dark, I feel depressed, I'm upset. That's not imminent. I might hurt somebody someday is not imminent. I bought a weapon and I plan to use it tonight. Well, that's imminent. And there are attorneys that operate under different confidentiality rules. Attorneys do not have to report. I call myself a mandated non-reporter. See, unlike therapists, attorney's obligation is almost always to the client, not to the state, unless the attorney is assisting the client in an ongoing future crime, which of course no one would ever do. I certainly wouldn't do it. Past conduct is perfectly okay and perfectly protected to talk about with an attorney and should be spoken with an attorney about. Seeking help to avoid a future crime, definitely protected and definitely should be spoken about to an attorney. Attorneys do not have to report. No obligation to the state. The only obligation is to the client. Now, mandatory reporting laws are designed to protect the vulnerable, obviously. They're not designed to punish people for seeking help, but the system works only if people understand where the real lines are. If someone out there, a friend, is struggling with thoughts, impulses, compulsions, or shame, the biggest danger is silence. Silence leads to collapse. Collapse leads to crisis. Crisis is exactly what these laws want to prevent. So if you're listening or you have a friend who's afraid to seek help, tell them this. Help exists. It is confidential. It is legal. And there are ways to talk to professionals without triggering automatic reports. Understanding the rules is power. And sometimes that's what saves lives.